The Colorado GOP is fighting to keep Donald Trump on its March primary ballot and has filed an appeal to the U.S. Supreme Court. The appeal will extend the state court's pause on the ruling indefinitely until the Supreme Court decides whether to take up the case and issues a final decision. This brings the 9 federal justices into another controversy involving the GOP frontrunner. The Supreme Court is already involved in other matters related to Trump's election subversion criminal case. The Colorado GOP argues that the state Supreme Court violated the First Amendment rights of political parties by excluding Trump from the ballot. They also claim that the court incorrectly applied the Constitution's insurrectionist ban to presidents, even though the provision doesn't explicitly mention the office. The party argues that only Congress, not courts or state election officials, can enforce the ban. The Colorado Supreme Court previously rejected these arguments and blocked Trump from the ballot. The party is concerned that other states might adopt Colorado's rationale to exclude Trump as well. Similar challenges are pending in Maine and Oregon, and some Democratic officials have urged election officials to consider removing Trump without a court ruling. The petition to the U.S. Supreme Court comes after the Michigan Supreme Court rejected a similar lawsuit, allowing Trump to remain on the ballot there. The outcome of the Colorado appeal will provide nationwide guidance on this constitutional matter. There are upcoming deadlines that could influence the speed at which the Supreme Court acts. Colorado election officials must certify the list of candidates for the GOP primary ballot by January 5th, and the primary itself is scheduled for March 5th, which is Super Tuesday. The Colorado Supreme Court's decision on December 19 stated that Trump is constitutionally ineligible to run in 2024 due to his conduct on January 6, 2021. The court ruled that Trump incited violence and disrupted the peaceful transfer of power. They also determined that removing Trump from the ballot does not violate the Colorado GOP's First Amendment right to political association. The lawsuit was filed by a group of Republican and independent voters, in coordination with the government watchdog group Citizens for Responsibility and Ethics in Washington. A district judge initially ruled that Trump is an insurrectionist but exempt from the 14th Amendment's ban. The state's high court affirmed the judge's findings about January 6 and concluded that the ban does apply to Trump.